Hello, everyone. I'm Shahzeb Usman, and we welcome you to our conversation. Today, we will be discussing the state, statelessness, and international law, a third world perspective. We are very happy to join with Ms. Sumedha Chaudhary, who is a PhD candidate and research fellow at Melbourne Law School, Australia. Sumedha has previously worked with the United Nations High Commissioner in India. She holds an MSc in Refugee and Forced Migration Studies from the Refugee Studies Centre, University of Oxford, United Kingdom, and an LLM with specialization in international law from South Asian University in India. Her PhD research focuses on the rising crisis of statelessness and ethno-nationalism in post-colonial states, and how international law contributes to it. Hello, Sameda, how are you?
Hi, Sejal. So nice to meet you finally.
Yeah, it's
Yeah.
good to see you
Hi.
too, especially it's our
Mm,
first time seeing each other in a video call. So it's very good to see
yeah.
you. Um,
It's good to
my
put
first,
you in person. Yeah.
yeah, definitely. So my first question is, can you describe how the crafting of international law on statelessness was largely the product of European interests, and the structure of international law has actually increased statelessness rather than decreasing it?
Thanks. I think that's a very thoughtful question and a great one to begin this interview today. So I think to answer this question, I would reflect back on the very characteristic of international law. And as we can look at how many trail scholarship, third world approaches to international law scholarship have shown how international law has been a central feature of colonialism, or how colonialism was central to the creation of international law, and how it helped in creating this legal system that accounted for relations between the European world and the non-European worlds, and how the whole colonial transaction took place. So if we look at international law, its structure is colonial. It helps us, or at least for my own project, to see how statelessness or the making of statelessness conventions were no less different. And so I think it's the idea of how like the concept of state sovereignty emerged in international law. And when you said, I think that's very reflective of how the structure of international law has in fact led to the rise of statelessness, at least partly contributed to it. So we see how the argument of state sovereignty is often pitted against by states. And even when there is this idea of human rights protection, you'd always see both colonial and post-colonial states using the concept of state sovereignty and saying that, oh, we are a sovereign state, and whatever we're doing is our internal matter within the state. And we have seen that many times been employed by states, even with the recent rise of statelessness in post-colonial states like Myanmar, India. See how this circular argument keeps on coming. And I think that's something very intrinsic to the idea of international law, where state sovereignty becomes a central argument, and that's
Mm,
often pitted against the idea of human rights. So I think that's the same idea how European interest was used in the making of the Statelessness Convention, because they wanted to have this particular law, and uh, which would basically improve their ideas of how to curb citizenship for basically naturalized citizens, because that 1960s or 1950s, when the Statelessness Conventions, both the 1954 and the 1961 convened, that was also the time when decolonization process started, which meant that there was a greater responsibility, or how they saw it as a problem, to take care of the former imperial subjects. So one hand, they were making this law of how to protect stateless people, which was centrally coming from the Second World War idea of how there was massive displacement. But at the same time, when we look at it from the angle of decolonization, there were also a lot of people who were coming out from all these former colonial states, or the newly built post-colonial states, and countries like UK, France, they wanted to have a law, or basically an international law, which would protect their interests, and in the way limit the idea of what is citizenship, and how it was very much something that would only be given to natural born citizens. So basically very racial in the idea of who gets citizenship and who doesn't. And that was reflected in international lawmaking as well.
Mm-hmm. I think that's
Mm,
very interesting because when we see international law in general, it's again this
yeah,
the basic focus is on the states and how the
yeah,
states are responding to particular political crisis, what they say,
yeah,
the consensus of it, I feel, becomes international law. So it's very positivist in nature.
mhm,
And that automatically assumes concepts like state sovereignty, which is again, something which is a byproduct of colonial legacy. So
yeah,
I understand your point and I agree with it. And it actually takes me to my second question, which is about, do you think this era of decolonization has improved international law on statelessness from the perspective of global South, especially considering when we saw that the 1961 Statelessness Convention had much more representation from the global South as compared to the 1954 convention. So, do you think that this has actually uh, increased the representation of global South, this whole decolonization process, or as you said, this is just a vestige of the colonial times that has still
yeah.
remained in the structure? Do you think that?
Yeah, yeah, absolutely. I think that's a very good question. I mean, if you see it from the era of decolonization, my project, because most of the scholarship that emerges in terms of international law, specifically in my area of statelessness, that has looked at it from a very European angle, or mostly emerging from the Second World War. So the story would go as a romance where like all this whole international community set and came about how to protect our stateless or the stateless people, which is emerging after in the aftermath of the Second World War. But no one really talks about the story of decolonization because, as I said, this was also the time when decolonization was looming in this whole Asian African states. If we look at it from the angle of decolonization, things become really different, or the story becomes really different.
Mm,
It could be actually said as a romance, but more as a tragedy.
mm,
And
mm,
but at the same time, when you're asking what if it really made a difference, so I think it's quite interesting when you look at it from the both the 1954 convention and the 1961 convention, because the 1954 convention, that purpose was quite limited. It was to define a class of who is a stateless person and how their status or their could be regulated. And when we see the convention or the drafting history, there were a very limited representatives, and basically they were from Europe or the global north, and mostly former colonial powers. And they didn't discuss anything about the colonial legacies or even about the consequent massive displacement that took place after decolonization. But rightly, as you said about the 1961 convention, things were a little different, and there were many Asian, African, Latin American states coming and negotiating what would become the 1961 convention. But as we see later, or how I see the drafting history, if you read it more carefully, I feel that it didn't really make an impact on the stateless people, or how at the moment we see minorities are still in every country, or mostly in post-colonial states, are becoming stateless. Interesting, I remember this quote by one of the UK representative who said that it was a
mm.
happy medium between extreme views. And the
Okay.
extreme views basically meant that there was this global South countries and global North countries, but both of
Mm,
them were actually calling for the same thing, which was to have more rights to decide who becomes a citizen and who doesn't. So it was
mm,
not about, I think, protecting the right of the stateless person, but more about protecting the nation state.
mm.
And that is very much reflected in both the 1954 and the 1961 convention.
Yeah, I think that's very interesting. And uh, what I find very fascinating about all of this is that in all post-colonial countries, the mold of the society is such that even the most revolutionary people, people who claim to be, socialists, people who claim to be, very, very revolutionary, they somehow cannot get away from these very, very colonial ideas, which continue to, let's say, hamper the progress of the most marginalized communities, whether they are the working classes, whether they are the ethnic minorities. Somehow, I think these structures that are the West and these ideas, those very rigid
Yeah,
ideas, that are a product of colonialism continue to remain there, and we somehow just can't get over it. Like these are so
Yeah.
much entrenched into our global framework that somehow we
Right.
just can't get over it. So
Right.
I think that's something which domesticates any idea of extreme revolutionary, spirits. I feel it
Right.
domesticates a lot of times, and that is something which is fascinating to see as
Mm.
a thinker, but also very sad. Um, uh, but yeah, coming to my third question, I think I'll actually narrate apart from your PhD thesis. You said that the conceptualizing and negotiating the idea of statelessness around the nation state presumed a precise conception of social and political relations based solely on European imagination. If I put this in perspective of India and Pakistan, how do you see it? How do you describe this particular language that you have used?
Mm. Yeah, I think that's something I'm still trying to figure out. But
Hmm.
as I see it, I think as you have, I think that's a very that's quotes I think from the PhD part that I shared with you. But I started thinking about how the nation state presumes certain identity, and how, if we look at the idea of nation state, it emerged as this European idea. And there are many scholars like Talal Asad, David Scott, who talk about how the non European world was basically a conscript rather than a volunteer of becoming a nation state. Which
Hmm.
means that we were conscripted into becoming something by, as not just in the moment when decolonization started, say in India, Pakistan, the 1947 or the 14 August and 15 August 1947, but it happened over a period of time, and it happened right when colonialism as started in all this South Asian or other countries. So it's this process is reflected not just in the domestic sphere but also international. And I think this we always see things in terms of duality, that this is domestic law, this is international law. But I think there's a need to break those duality, because what states are doing in their domestic affairs are also reflected in international law. And what is happening in international law as a result is also reflected in the domestic making of the state. So I think it's a circular generative force that makes each other. And when we look at it as that process, we can also understand it in the terms of how statelessness came about, and how that presumed certain ideas of how what statelessness is, or how statelessness would be created. And as you said about how it presumed a particular conception of social and political relations that was basically very European in its imagination, that comes from the very fact that the nation state itself has been coming from this idea of what
Hmm.
Europe thinks of nationality, what Europe thinks as statelessness, and how this idea of nation state then gets impacted in how the post-colonial state is made, because the post-colonial state is not something that is coming out of nowhere, but basically from how Europe has imagined nation state. Because modernization, which was say a common euphemism for being Western, was actually employed in all these post-colonial imaginations of how
Hmm.
to become a nation state, how to be homogeneous, how to be unitary. And this was reflected in not just making of the statelessness convention, but everything that we see in the present times of how ideas are formed. So I think that's this idea of conceptualizing uh, and negotiating the idea of statelessness came into my mind. And when I'm playing with this idea of how what would come about when we see it as purely European in its imagination.
So basically, what I was trying to say here is that this principle of just lie that Pakistan subscribes is something very
Hmm.
unique because we are at least technically and legally saying that anybody born in Pakistan, except the children of diplomats, will be given Pakistani citizenship. Although
Hmm.
we haven't followed it to the core, I would accept that. But I think at least we believe in a state that at least has ideological foundation rather than on any ethnic uh, basis. But do you
Hmm.
think that, for example, what has happened in India, especially considering
mm,
we were discussing how domestic law intertwines with the international law here, that after
mm,
the passage of Citizenship Amendment Act in India, we have seen that there is a lot of problems that Muslims might not be getting citizenship after, this national, I think, registration move there. So all the people who can show that they were in India before, I think, 1971 can get citizenship and can be registered in this NRC. And even the people who are not Muslims, like Hindus and are I think it was Jains and Sikhs who are coming from Bangladesh or Pakistan. Even if they are coming after 1970, they can get citizenship. So in a way, effectively just excludes Muslims if they are not able to prove that they are not citizens were or they were not living in India before 1971. And but we have seen that the international law on statelessness hasn't really helped much in this regard because,
mm,
for example, I think the 1961 convention does say at some point that it does subscribe to this principle that anybody born can get citizenship if they cannot get any other citizenship. So they have this kind of reasoning within that particular um, within that particular convention. So how do you see that the international law on statelessness has failed Indian Muslims, especially after the Citizenship Amendment Act? What are your views on it?
mm. So I think yes, if we see the CAA, I mean, at least now there's also this whole implementation that they're trying right before the election. And in terms of the role that international law is playing, it's the first thing that is when we're talking about the drafting history, we see how all these states were negotiating, but by the end, they didn't sign up. They didn't become party to the Statelessness Convention, either to the Refugee Convention. So that makes an impact because India, Pakistan, mostly all the South Asian countries are not party to the Statelessness Conventions. And but I think many major advocates for international law are looking at other options that like India has signed the CRC, the State Child Rights Convention, but there also are like the ICCPR, ICSR. So there are other human rights treaty bodies where we that India is a party to, and how most international interventions are looking at those options of how to make India responsible for it. But as I mentioned in the beginning about how India has said that they are a sovereign state and it's a domestic affairs, there shouldn't be any intervention. So that's I think the paradox of international law, which comes about so frequently when we're looking at certain issues like this, especially when you look at the post-colonial states and how they're using these arguments of international law. So in one hand, there's this idea that international law could become a savior, could become this way or tool to help minorities or like to prevent the rise of statelessness. But at the same time, the state bodies are also using international law to say that, oh, international law says that I'm a sovereign state, so you shouldn't be telling me what I should do. So, like a state would say that. So that circular argument that keeps on coming is really sometimes problematic. But if we see international law as a strategic tool, I think then it becomes helpful because what do we do like with all the problems that international law had, but still it could be a strategic tool for intervening in domestic affairs, and especially when we look at it from minority oppression or statelessness, and if the state is not doing anything in the domestic matter, how do we move ahead with the use of law? And I think that way it becomes a strategic tool. And in this context, I think what comes up for me as this at this moment is the example of how we saw many UN bodies intervening in the Indian issue. Like,
Hmm.
for example, the Office of the UN High Commissioner for Refugees, Office of the High Commissioner for Human Rights, OHCHR, they filed an application before the Supreme Court of India asking to intervene as amicus curiae or friend of the court. And even though India said that we are a sovereign and there shouldn't be any intervention, see all these actions being taken up, or also I can tell you about the UN experts, like the special rapporteurs who recently, I think on 7th March, came up with this call for protecting human rights and ending violence against minorities. So even with all the problems, if I have to answer about how international law, whether Indian Muslims, I think it's a yes and no question. And
mm,
it's very difficult to actually say that, because I think even with all the problems, we need international law because there's nothing else at the moment. So maybe in long term, I could say that
mm,
it's not it's not the solution, but at
mm.
least for the current moment that we are in, or for at least for matters of life and death, I think
Mm.
law or international law becomes useful.
Yeah, I do understand your point and agree with it. But what I do think that at the end of the day, international law is more about tool, which is
Yeah,
defined by politics rather than the law defining politics. I think it's
yeah.
politics that defines law. And I do think international law does provide some remedy, but I would say more in the human rights perspective, because international human rights law, I feel, is quite developed. It is even saying some things like, that you cannot refool someone back to the country which has a, chance of torture. The Convention Against Torture is very clear on that. Then we also have the customary international law, which also says that it's a prohibition of non-refoulement. So the idea is that I feel that you do find a lot of protection from maybe the human rights perspective. But as far as I think the conventions on statelessness, I think they doesn't seem that effective, if you agree with me. But again, I would accept that international law at least provided some rhetoric to countering what India did in relation to Citizen Amendment Act. That I do agree. But going from India to UK, we saw that very famous case of Shamima Begum, where
Mm,
that woman was deprived of her citizenship, and I think the Home Minister at that time, Sajid Javed, said that since you get citizenship in Bangladesh, we are not violating the Convention on Statelessness. So, how do you find this attitude and this newly emergent attitude, especially after this, war on terrorism and all that, uh,
mm.
that Western countries are depriving immigrant children of immigrants who are generally dual nationals or have the possibility to acquire nationality of their origin country to deprive them of citizenship of their Western countries. So, how do you find this new idea that has propped up in the Western countries? Do you think that the international law of statelessness can provide any remedy when it comes to this kind of attitude?
Question about deprivation of nationality, that's so intrinsic to the idea of also how, like, of discrimination, because discrimination and racism becomes the really defining feature of how someone is denationalized. And
Hmm.
the Shamima Begum's case is a textbook example in this,
Hmm.
because Shamima's parents has a Bangladeshi heritage, and
Hmm.
even though
Yeah.
Shamima was born in the UK, the
Hmm.
UK government saying that she could be stripped of her citizenship because she won't be stateless, that really shows how racist borders are and how racist laws are. And
Hmm.
because when Shamima moved to this Syria, that was in 2015, and she was a UK citizen, and this something like this is very much central to how the idea of citizenship works, because the law says that you cannot denationalize someone, because as long
Hmm.
as they might turn into a stateless person. And
Hmm.
when I was mentioning in the start of this podcast that for states like UK, France, it is very central that there is a distinction between how you deprive someone of nationality if they are naturalized citizens as opposed to
Hmm.
someone who's a natural born. this is what we see being unfolded in the case of Shamima Begum. Because if I think the question would be what would have happened if that was a person was born and was white and was as according to the state a nationality or their own, as opposed
Mm,
to the idea of others or foreigners. How no matter even if Shamima was a citizen. So I think even though you get the right to citizenship, if you
mm,
are a person who doesn't fit into the ideals of what should be a citizen, then
mm,
there is this possibility that you are discriminated. And
mm,
Shamima's case has come in the limelight, but there has been many other cases in Western countries where naturalized citizens were deprived of their nationality, saying that, oh, go back, you can go back to your own country. But the problem is, in not many many cases, countries who the Western government would say that you can go back would say that no, if they are not our citizen, because in Shamima's case, Bangladesh said that Shamima is not a Bangladeshi citizen. And even in terms of, because we're talking about India, India doesn't allow for dual citizenship. So this this is very interesting how the law allows you to actually discriminate someone in terms
mm,
of the color of your skin, and
mm,
that's something very much intrinsic to the colonial idea of international law that I've been talking about. And even at the moment, UK has this law that they can, if they doesn't become stateless, they could be denationalized if it means that it's for the public good, or if the citizenship has been obtained by fraud, or if they could claim citizenship elsewhere. So in all these laws, we see this tendency of othering this foreigner, the assumed
mm,
foreigner who is
mm,
naturalized, as
mm,
opposed to a natural born citizen. And
mm,
in terms of if international law can provide any remedy, I think this whole basis of discriminating against naturalized citizens is allowed through this whole idea of international law. That was the central reason why UK, France were negotiating how there should be a different law for naturalized and national born citizens. So I'm not sure how, at least the statelessness law could remedy the situation, but as we have discussed, human rights could be one aspect of it if this case goes to outside the UK. So
mhm.
let's see
And you
how
mentioned the
it
word
turns out.
denationalization. What do you mean here?
Okay, so when someone is in very simple, if this technical legal sense, if someone is stripped of their citizenship, they
Mm,
use the term denationalized.
mm,
So it's like
yeah.
nationality, but then it's stripped.
Mm,
So
mm, mm.
they would be
So,
using the
in a
word
way, yeah,
denationalized. So yeah,
as the word
basically just
implies.
stripping off citizenship. Yeah,
But can't UK do it? Because from what I do, in Shamima Begum
yeah,
case, what they argued was that Shamima Begum can get a Bengali citizenship, although the
mm.
Bangladesh said no, she can't. So she was put in a very difficult spot. But can the UK? I don't. Can the UK still do it if there is no other way they can get citizenship? So, for example, Indians can't get dual nationality, right? They get the origin card, but they have to surrender the British nationality to get the Indian nationality.
Yeah.
Pakistan does allow dual nationality, and I think it's one of the only countries in this region. I think China doesn't, India doesn't, probably Iran also doesn't. So, do you think that, for example, the UK can even get away with, stripping people from nationality, even if there is no other way they can get a nationality? Because stripping away a nationality, especially from of people of color, as you mentioned, is like a civil death. You are because nationality gives access to all the social and political and economic rights in the Western countries. So, do you still think that UK can get away with this if there is no other way? There a nationality is there.
Uh, that's a very good question. I think in terms of the existing international law, it clearly says that if there's a possibility of rendering you stateless, you
Mm,
cannot be stripped of your citizenship. But
mm,
at the moment, the UK is making a lot of laws which are in violation of many international human rights obligations.
mm,
So And because Shamima's case is still pending, and we have to see how it turns up after the court decides on it. But from a very technical international law sense, the in UK cannot do it. They would be in violation of their
Yeah.
legal obligations, especially because they are party to many of these conventions, which specifically says that you cannot make someone stateless. So that's why I think the argument they're making was that, oh, she can acquire Bangladeshi citizenship.
Yeah.
So I think only we'll have to see through with time what happens. But if I have to answer from a very technical legal sense, UK is not allowed to do this. But I think
Hmm.
that back again, it comes to the idea of how most of
Hmm.
these countries evade their responsibility using the sovereignty argument.
Hmm.
So yeah, let's see what happens.
Hmm. 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 Yeah, that's very interesting, and I think I do find an element of racism here, although they couch the language very in a very legal manner. They say that we are only doing it because that person can get another nationality. It's not
Hmm.
because that it's the color of their skin. But intrinsically, I think it will only impact the people who are coming from, the former colonies of theirs. Mostly, it is the former colonies, because
Yeah,
I think we have both studied in the UK, and we have seen that that most of the people in UK are from, Commonwealth. You wouldn't find much from other places. So again, as you were saying, and we were starting the podcast from how racism is embedded in the international legal framework, and it might not be in the language, but it's in the effect of that language. Definitely, that is
yeah.
something which we see. With that, I can we conclude our conversation. I think it's a pleasure to talk to you, and I learned so much from you, and I'm really happy that you take time to enlighten us.
Thank you so much, Shazam. I had a great time. Thank you.
And I hope you come to Pakistan sometime. And we are
Yes.
from neighboring countries, so it's great.
Yeah.
Islamabad
Let's
is a
have all the
wonderful
kebab
city.
we were talking about.
Yeah, yeah, we were talking in that call. I think very, very amazing
Yeah.
food. And I know you love Pakistani food. And it's Ramadan right now, so I
Yes.
think food is something I am
Yeah.
craving a
I
lot
should
right now.
stop talking about food.
No, definitely.
Yeah.
And Islamabad is a
Thank
wonderful
you.
city, so I hope you come to our studio sometime and we can have
Yeah,
somehow an
hopefully.
in-person
Yes.
conversation. Yeah. Thank you so
Yeah, it'll be
much.
really good. Yeah, thank you
Thank
so
you.
much. Bye.
Bye. Bye. Bye.